Hi, everyone. Good morning. Thank you for joining our webinar. My name is Ariella Wagner. I am the founder of SunRay Construction Solutions. SunRay helps general contractors, subcontractors, and suppliers with their lien management and waivers. We secure over $10 billion annually. I would like to introduce the fabulous Alex Barthet, a brilliant Florida construction lien law expert. Today's webinar is the topic is common lien and release traps and how to avoid them. So without further ado, I would like to introduce the amazing Alex Barthet.
Thanks, Ariella. My name is Alex Barthet. I'm a board certified construction attorney in Florida. And today we're going to talk about common lien and release traps and how to avoid them. If you have questions during the webinar, use the GoToWebinar chat box, which should be on your screen. Make sure to type in your questions and we will answer them at the end. Please do not include the names of any people or companies in your questions. So what are we going to talk about today? We're going to talk about 7 lien law traps. We'll also talk about 3 release traps that you need to be aware of, and then we'll answer any questions that you have. So let's get started. So let's start by explaining what the lien law rules are so that you understand why the traps are in fact traps. So in order to preserve your lien rights, the first step you need to take is you need to, within 45 days, no later than 45 days from your first work, you need to serve a copy of the notice to owner on the owner if you are a subcontractor or supplier, or a subcontractor. So what that means is you need to have this document served and in the hands of the owner and contractor no later than the 45th day. It does not apply, meaning you don't have to serve a notice to owner if you are in direct contract with the owner. It doesn't hurt. It's a great collection tool to send notice to owners, even if you have a direct contract with the owner, but it's not legally required. Step 2, within 90 days of your last work, you must record a claim of lien. You can record a claim of lien while you are on the job. Sometimes we have clients that want to record a lien while they're still working in order to add some pressure if they have some outstanding balances, but they continue to work on the project. So don't think you have to finish in order to record a lien. You could record a lien while you are working on a job. Step 3, within 15 days of the lien being recorded, you need to serve it on all interested parties. If you use SunRay Construction Solutions to do your notices, then they will take care of the research for the notice to owner. They will do all the research for the claim of lien and make sure that everyone that needs to get a copy does in fact get a copy. Step 4, those who have a direct contract with the owner need to serve, not record, serve a contractor's final affidavit at least 5 days before you file a lawsuit to foreclose on the lien. We recommend doing it at the time that you record your claim of lien, but the deadline is no later than 5 days from when your lien is recorded. No later than 5 days from when you file suit to foreclose on your lien. And then the last step is no later than 1 year from the recording date of the claim of lien, you must file a civil lawsuit in court to foreclose on the lien. If you do not do it by that time, your lien will expire. There is no such thing as re-recording the lien or extending the lien deadline. The only way to extend the lien and keep it alive is if you file this civil action in court. So these are the 5 steps to secure your lien rights. Let's start going into the lien law traps. But before we do, if you would like to get a handy desk tool for free that will show you what to file and when to file it, depending on the type of project you're on and what role you serve, you can go to lienomatic.com and we will send this free desk Lien-O-Matic calculator to you. It's great to use in case you need to verify, do I need to send a notice here? If I'm a subcontractor, it answers all of those questions. You can keep it on your desk. Go to lienomatic.com. Okay, trap number 1. Service of the notice to owner is the date it is received, not sent. So, for example, if you put your notice to owner in the mail and it has to go certified on day 41 from your date of first work, it may not be received by the 45th day. What if it gets held up in the post office, or something goes wrong, it falls off the truck, and it's not received by the 45th day? That notice to owner is no good. Now, there is a workaround, and that is if you serve your notice to owner by the 40th day, and have it confirmed as being hand delivered to the post office, then no matter what, it is deemed properly served, even if it never gets to the owner. So if you use SunRay, then what they do is they take your notice, they create a daily manifest of all the notices that they're generating. They go to the post office and have it stamped every day. And if that's done by the 40th day, then if the post office truck blows up with your notice and it never gets to the owner, it's still considered good service because you followed the 40-day rule. So keep in mind about that with respect to the notice to owner when it has to be received, not necessarily sent. Trap number 2, the general contractor needs to receive the notice to owner. Most people don't know this, but the notice to owner needs to go not just to the owner, but to the general contractor. This rule will invalidate your lien if you are a subcontractor or a supplier to the subcontractor. So if you are a sub or a supplier to a subcontractor, then your notice to owner needs to go not only to the owner, but it must be served on the general contractor. If you don't properly serve the notice to owner on the contractor, as well as the owner, so if I'm the material supplier to the electrician and I only serve my notice to owner on the owner, I do not have lien rights. The people that are supposed to get a copy of the notice to owner are listed in the notice of commencement. And those are all the people that need to receive a copy. The general contractor is one of those parties listed in the notice of commencement. So remember, if you don't serve the general contractor with the notice, you have no lien rights. But again, if you use SunRay, they will go ahead and take care of making sure that everyone that needs to get the notice receives the notice. Trap number 3, last work does not include repair, punch list, or warranty work. So the last date of work that starts the 90-day countdown must be approved work, labor, or delivery of materials under an original contract or upon an approved change order. So if you go back and repair something or you go back and do warranty work, that does not reset the 90-day countdown. So let's take an example. Let's say you are a window contractor and you're owed $10,000. Your last date that you actually do real work on the job is March 1st. But it turns out that one of your windows is defective and the owner refuses to pay you your $10,000 until you fix it. Well, by the time you order the replacement window and it gets delivered, it's now July 1st, or delivered and installed, it's now July 1st. Well, from a lien rights perspective, your last day of work is March 1st. It's not July 1st. And 90 days after March 1st is May 30th, meaning if you waited till you fix the window to record your lien, you will have lost your lien rights. So remember when your last work is and what it doesn't include. It does not include repairs, punch list, or warranty work. Trap number 4, last work does not include the mere act of passing an inspection. So it is the last date you did real work under your base contract or approved change orders or delivery of materials. The date that you actually pass an inspection, a TCO or a CO or a CC, does not extend the time to record your lien. So let's take an example again. let's say the last day you did real work on the job site was March 1st. You called for an inspection and the inspector came on March 5th and passed you. Now on March 5th, you showed up and you just stood there as the inspector looked around, you answered a few questions, they passed the inspection. For purposes of your lien rights, your last date of work and when the 90 days starts to commence is March 1st, not March 5th. Trap number 5. Last work does not include, has nothing to do with the day you send your bills. Again, I sound like a broken record, I know. The last date of work is the day you do real base contract or approved change order work or the delivery of materials pursuant to the contract or an approved change order. The mere act of sending an invoice or a payment application does not extend the time to record a lien. Sometimes clients that may have us record their or prepare their lien, they say, well, I sent my invoice on, February 7th. I said, well, that's great, but that doesn't matter for the lien law. I need to know when you were on the job actually doing work. So let's take another example. If you did your last work on March 21st, but you didn't send your bill until April 1st, the day that matters for lien law, 90 days, is March 21st, not the April 1st date you sent the lien, sent your bill. Trap number 6, 90 days is not 3 months. I've told you have 90 days to record your claim of lien. Well, 90 days is not 3 months. Some months have more than 30 days. Some months have fewer than 30 days. So let's take an example. 3 months from June 15th is September 15th, but 90 days from June 15th is September 13th. So the way you count 90 days is day 1 of my 90 days is the day after you actually did work. So today I show up, I finish all the drywall in the unit. That's my last day of work is today. Tomorrow is day 1. I keep counting every day and weekends and legal holidays through and including the 90 days, and that's the 90 days. That's how you calculate when the 90 days for your lien rights expires. We have another tool for you also for free. It's called the Lien. It's a handy desk tool as well that will calculate when your 45 days for your notice to owner and your 90 days for your claim of lien or notice of non-payment is due. So you no longer have to count on your fingers. You can go to calculien.com and we'll send one to you for free. Okay, lien law trap number 7. Don't just count the days. You need to look at a calendar to account for weekends and legal holidays. Let me explain what I mean. For both the notice to owner, which is 45 days, and the lien, which is 90 days, if the last day falls on a weekend or legal holiday, it rolls to the next business day. The reason is that if the 90th day is Sunday, I can't go to the clerk's office and record my lien on the 90th day. I can only do it on the next day, which would be the Monday. So this may give you more time to serve your notice to owner or record your claim of lien. So let's take an example. If your 90th day to record a lien is Saturday, it then rolls to the Sunday, and then it rolls to the Monday. And if Monday, the courts are closed, so you cannot record your claim of lien, it rolls to the next day. That's Tuesday. This means you could have as much as 93 days to record your claim of lien. Okay, let's talk about some release traps, some traps we see clients make with respect to exchanging releases for checks. So trap number 8, email copies of releases are valid even if the original is never sent. So some people believe that if I sign a release, I notarize it, I have the blue ink copy in my possession, and I send that copy to somebody else, that because I'm holding the original, the copy they have is unenforceable or has no force and effect. That is not true. If you send someone a copy of the release, then you are obligated by the terms of that release. So if you send someone, for example, a $10 unconditional release, meaning it has no condition of payment, and you never get the check, you may have given up your lien rights. So you should only provide expressly conditional releases before you actually get the funds. So the SunRay system has conditional releases. So if you want to use their releases in the system, you would want to pick a conditional release. The conditional release can be written many ways, but here is an example of the language that would make a release conditioned. Notwithstanding anything to the contrary, this waiver and release is conditioned upon and not effective until the undersigned receives paid funds of blank. So if you're expecting a $10,000 check, that's what you're going to put in the blank. You can handwrite this in, you can type it in. It needs to be in the release if you are not, if you are exchanging a release without actually getting the funds. Now, you should also be aware that this is something you should do when you exchange a release for a check at the moment. Let's say you go to the owner's or contractor's office and you give them a release and they give you a check. Well, what happens if that check bounces? So you want to make the release conditioned on you actually receiving the funds. And I would suggest to you that if you have any doubt that the funds are good when they give you a check, you need to make that release conditional as well. We have a tool to make your life easier to the extent you have to sign paper releases. If you go to makemeconditionalstamp.com, we have a stamp with that exact language that I read to you. So you can keep it on your desk when you have to sign a release. You can stamp the release and it will put that conditional language on. You write in the amount of the check and off you go. You have now made that release conditional. You can go and get one for free at makemeconditionalstamp.com. Okay, release trap number 9. Releases that are only titled as conditional may not be. So you need to read the entire release. We see many releases that the title of the release is conditional partial release of lien. But when you read the release, it is not conditional. There is no conditional language in the release. The title by itself does not make a release conditional. It has to have conditional language in the body of the release. So you need to add the language I told you. You need to use the stamp. You need to do something more to make the release conditional other than merely relying on the title. Okay, trap number 10. Watch out for $10 releases. If you are the party that is receiving the money and giving a release, I recommend that you strike out the $10 and you write in the amount that you are actually expecting to receive. So let me give you an example. If you are giving someone, you're expecting a $10,000 check and you're going to give someone a release and the release is a $10 release, what happens if you go pick up the check and it's only $8,000? So remember that the release says $10. It doesn't say 10,000 or anything else. Unfortunately, under the law, $10 means that you received some value of any amount. Could be $10, could be $100, could be 8,000 or 10,000. Well, $8,000 is some value. So barring some other language in the release, if you show up and give someone a $10 release and they give you an $8,000 check instead of a $10,000 check, you have probably given up your rights to that $2,000. So if you are getting a check and giving a release, you should state the amount that you are expecting on that release. So in my example, you should cross out the $10 and write in $10,000. What this does is if you only get 8,000, you can argue later, well, I gave this release for 10, they only gave me 8. Belt and suspenders would say, go one step further and add the conditional language in the release. So the conditional language we talked about a few points ago, put that in the release as well. So there's no doubt that this release that you're giving is conditional conditioned on you getting $10,000. Now, for those of you that are listening to this and you also give checks and get releases. So maybe I'm a GC and I'm paying my subs, or I'm a subcontractor and I'm paying my subs. It's great if you can get the people that you're giving the money to and getting a release, if you can have those releases say $10. So when you are giving a check and getting a release, you'd like those releases to say $10. But also keep in mind what we talked about when it's in reverse. So with that, Ariella, we are done with the 10 traps. Do we have any questions?
So far, we do not. Oh, just one came in. Can we get a copy of this, or will it be available online? Absolutely, you will be getting a copy of this webinar. You'll have it in your inbox by the latest Monday morning. So if there are any other questions, I know that there are some general contractors on the phone. There we go. If a contractor sends me a release, can I add the stamp to that release? And I think that, again, you have to look at your release that you're given. So if you're the sub that asked that question and it's a conditional release versus an unconditional release, then you need to add that stamp. So it's conditioned upon payment. So Alex, I think that there's some confusion in general of unconditional for the subcontractors out there, not the GCs, the subs, the conditional versus unconditional. What exactly does that mean then?
So the condition that we're talking about, whether it exists or doesn't, the conditional versus unconditional, is whether the release is expressly conditioned on payment. Many times when you read a release, it'll say for $10 or $10,000, the receipt of which is acknowledged, right? When it says those words, that means that it presumes you have already received the money, when in many instances you are signing a document that says that and you have not yet received the money. So what you need to do is you need to make that release conditional by adding conditional language, making it clear that I am giving you a release today for funds tomorrow, right? I'm not getting the funds at the moment that I'm giving you the release. So that's why we want to make it conditioned on you actually receiving the funds. We also talked about the idea that maybe someone gives you a check and the check doesn't clear. If you want to make that release conditioned on you actually receiving the funds, you also have to make it conditional so that your release is good only upon your receipt of the funds, not your receipt of the check. Are there any other questions, Ariella?
No, we'll just do our really quickly, our pop quiz. The first one is definitely a tricky answer, or tricky question. So if you answer this correctly, you could put your answer in the box on the right. What is the NTO deadline in Florida? And let's see if anyone answers that one. I know we had that question. We have this question all the time. Does anyone want to answer that for a gift? I think that person answered. Good job, 45 days. So you will be getting a gift. And remember, it's really critical that the notice needs to be received. The language is served, but for everyone that's on the call, it's received. They have to receive it, sign for it. And again, SunRay sends those out by the 40th day with a stamp manifest. So if the owner, general contractor, don't receive it by the 45th day, you are golden. All right, and the last one is, what is the lien deadline in Florida? Who is going to answer that one correctly? I know someone on this call knows the answer because I know I've spoken to some of you before and you guys can teach this. All right, well, I see an answer and it's 90 days. Great job. You've 90 days from the last day that you're on the project to lien it. All right, so our next slide. For our customers and new people that are on this webinar, you could download a project information sheet that will help you get all the information you need on your projects. We have lien law rules online. You can review all of your lien laws, again, online. You could share them with people in your office so that you know your deadlines. And again, we have an awesome calculator online as well for you, so you could calculate your deadlines. And you could just click on that QR code and it will take you right to our website. And then our next slide here is our next slide there, Alex.
Is it coming? I clicked it, I promise.
Oh, no problem. SunRay has a new service to help our customers. It's SunRay SR Receivables. So now we are going to help our customers collect their money. So if anyone has any questions, feel free to call that number or reach out to me directly at any time. But here you can call that number. And one of our last slides here, we have our next class on credit and collection best practices. This is an absolutely fabulous class that everyone should be signing up for. And then of course, the next one, how to get the bonding company to pay, because I know how many emails do I receive every year. And Alex, you know what? I've sent this claim on bond. I haven't heard from them. What is going on? I'm owed so much money. So this is a really great class. I highly recommend sunraynotice.com. And then there you go. We have our live seminars, and we have them throughout the state of Florida this year for everyone. So our first one is next month in Boca. Then in April, we have one in Fort Myers, Miami, and in Tampa. So if you want to attend any of our live seminars, we go really, really, really in depth into all these subjects that we went over today. And then last but not least, our next slide. Feel free to give us a review. It means a lot to us. Feel free to just take your phone, click on that scan code and write a review if you learned something and you received a golden nugget. So Alex, thank you as always for doing such an incredible job. I hope everyone received lots of golden nuggets. If you have any questions, our contact information is on the next slide. We are here to help you. No question is too silly. And if you didn't understand something, please feel free to reach out to us at any time. So Alex, thank you so, so much for everything. And I wish everyone a sunny day.